Welcome to the Contract Law Lecture Series at the University of the West Indies Faculty of Law at Cave Hill. This lecture is on contractual terms. Let's start with a brief overview of the lecture. I'll start off by introducing you to the concept of contractual terms. We'll then look at the distinction between contractual terms and mere representations. We'll then move on to something called express terms and implied terms. And finally, I'll offer a brief summary. As we know, contracts can be concluded in various ways. They can be concluded in writing, orally, or even by conduct. All of that is possible. However, before a contract is formed, parties would usually interact in some way. They would, for instance, exchange letters or exchange communications. They would talk, they would negotiate, they would perhaps act in certain ways. And once a contract is formed, we then may ask ourselves, what of all these things that went before the formation of contract? That means, for instance, which part of the negotiation, which part of what was said as part of the negotiation, which part of the correspondence that parties exchanged, which part of that is part of the contract and which part is not. Now, the way to distinguish what is and what is not part of the contract is to call what is part of a contract a contractual term, whereas what is not part of a contract is called a mere representation. Now, the answer depends on a number of circumstances, on obviously what was said, the way it was said, whether it was intended, even things that were not said at all. We have to look at the totality of the circumstances in order to decide whether something is a part of a contract, is a contractual term, or whether it is a mere representation. The distinction between what is part and what is not part of a contract is of crucial importance. That is because only contractual terms are things that we can sue upon, whereas mere representations we can usually not sue upon. In other words, where a party makes a statement and we determine that it's a contractual representation, and afterwards, after the contract is formed, it turns out that that statement was not true or didn't turn out to be true, well, then the other party can sue. However, if what a party said was a mere representation, or perhaps their conduct was a mere representation, then the other party, once it turns out not to be true, or once it turns out to be different than what had been said, cannot sue. That's really the crucial difference between a contractual term and a mere representation. Now, many tests or criteria have been put forward, and we'll look at a number of criteria that we can use to try and figure out whether something is a mere representation or whether it's a contractual term. One test that's been put forward is as follows. A statement is sufficiently important that, but for the statement, an offeree would not have entered into the contract. So it's about inducement. Is something that is said so important that the offeree says, all right, I agree, I go ahead, the contract is formed? Did it induce the contract? Did the statement induce the contract? That's really what we're asking here, and usually, if the answer is yes, then usually that what was said is indeed a contractual term and not just a mere representation. However, we need to be careful, because sometimes you might come across a situation where the answer to this question is yes, and nonetheless it is a mere representation. It's not a contractual term. So there isn't really a magic formula. There isn't one test that I could give you which would always answer the question of whether something is a contractual term or a mere representation. In the end, we have to look at a whole number of different criteria to come up with our answer. There's an early case we can look at which helps us distinguish between contractual terms and mere representations. And that's the case of Halbert-Simons and Buckleton. What happened in this case was that Halbert-Simons was a merchant company that was underwriting shares. Buckleton was interested in buying some shares. So he called Halbert-Simons, and one of their managers, so that means a manager of Halbert-Simons, mentioned that the company that was at issue, the company whose shares were being issued, was in fact bringing out some rubber plantations. Buckleton was very impressed, and based on that statement went ahead and bought lots of shares. Later on, it turned out that the shares didn't perform well at all, and there was far less rubber being brought out than had been anticipated, and so Buckleton sued. Now, the House of Lords was faced with the question, of whether this statement regarding the rubber company and the fact that it was being brought out was a contractual term or whether it was a mere representation. Very importantly, the House of Lords said that the manager, when he made that statement, did not intend to be bound. He did not intend that statement to be a contractual term, a statement upon which Buckleton could later sue. He was merely providing information, but not information of the kind that he would make himself liable to be sued later on. Now, this is an important distinction because, as we saw, sometimes it is said if something induces a contract, it's probably a contractual term. And here we have a case where something induced a contract, but it was held not to be a contractual term. So the question we could ask is, did the parties intend that there should be contractual liability in respect of the accuracy of the statement? And the test is an objective test. It's a reasonable man test. So a reasonable man who had observed the conversation between Buckleton and the manager, what would they have concluded? And in the eyes of the House of Lords, they would have concluded that indeed this was a statement that was a mere representation. It did not intend to be a binding statement. The manager did not intend to be bound by that statement going forward. It was merely providing information. Another question we can ask in terms of the criteria to be considered is, did the party making a statement have special expertise? This is another very, very important criteria. So, for instance, in Oscar Chess and Williams, that's a case of a party making a statement who did not have special expertise. What happened in this case is that Williams was selling a car. And Williams was just a layperson, didn't have any special expertise about cars. And he was asked about the car's model year. And in fact, I think it was 1939, and he said it was 1946 or 47. So he represented the model year as being newer than what it actually was. But remember, he was a layperson. Now, Oscar Chess went ahead and bought the car, relying on that statement. And then later it turned out, of course, that the statement was incorrect. The court held that since Williams was a layperson, he had no special expertise in relation to cars, his statement regarding the model year was not a contractual term. It was a mere representation. However, the reverse happened in Dick Bentley and Harold Smith. And in this case, the buyers were looking for a particular type of car which was going to be of, the engine was going to be new, and the car was described in a very particular way. And the seller said, yes, here is such a car, and the engine has, I think it was 20,000 miles on it, or 20,000 kilometers, whereas the actual age of the engine was much older, and it had over 100,000. So here the sellers were indeed experts. They knew about cars. They were a car dealership. So the court held that statement in relation to the mileage was in fact a contractual term, because sellers who are experts should know what they're talking about. Now, you'll see that some of these cases appear again because there's multiple ratios coming out of those cases. And in fact, all of these criteria can be applied, but probably in a lot of scenarios they may not be relevant. So we have to sort of choose which ones are relevant to whatever scenario we're looking at. So for instance, another ratio that came out of Dick Bentley and Harold Smith is whether a statement induced a contract. If a statement induced a contract, then in all likelihood, as we already saw, it means that it is a contractual statement. Now here it induced a contract because the buyers were looking for a very specific type of car with low mileage on the engine. So once that was given, once they were told here is such a car with low mileage, of course that particular statement regarding the low mileage is what induced the contract. Another factor that may be considered, and again, just bear in mind that not all of these factors will always have to be considered. It depends on whatever situation you're looking at. So this is just a selection of different criteria, and whatever situation you're looking at, you see whether these criteria apply or may apply, and then you test them accordingly. So sometimes contracts will state words such as far as the vendor knows. Again, this can be done in writing or this can be done orally. What happens when a contract or the negotiations leading up to a contract include those words. As far as I know, such and such. Well, the court held in Gilchester Properties and GOM that if those words are used, and this was a case about the sale of a house, the question became whether the seller who had qualified their statement with the words "as far as the vendor knows," whether that became a contractual term or whether that was merely a representation. And the court held that that was a mere representation because clearly the vendor has expressed their intention not to be bound by that particular statement. So look out for those kinds of words. They would tend to suggest that whatever is said after those words is a mere representation. Now, there's another criteria that we can look at, and sometimes it may be very crucial and sometimes it may not, but again, it depends on the particular circumstances. Statements made closer to the time of agreement are more likely to be terms. Now, that's a general rule. And again, we have two cases that we can contrast. So in Routledge and Mahncke, this case was for the sale of an old motorcycle. And the seller again had misstated the age because they were not an expert. Now that was one reason why perhaps the court held that it was a mere representation. But perhaps more importantly, the buyer said they would think about it. So the contract was not formed immediately. The buyer went away and thought about it for a week or so. And then the buyer came back and bought the motorcycle. Later it turned out that the motorcycle was in fact much older than what the parties had thought. Now again, the seller was not responsible, so there was no breach of contract because the term of the age of the motorcycle, the term when the seller stated how old the motorcycle is, that term was deemed not to be a contractual term. It was deemed to be a mere representation because, I guess is one of the reasons, because the buyer went away and had a week to think about it. The buyer had a week to research that question, to look into it him or herself. So this was a statement made quite a long time before formation of contract, and therefore the courts held that it was not a contractual term, it was a mere representation. However, we can contrast that with Van den Eschert and Chappell, which was for the sale of a house. And the buyer and the seller had in principle agreed, and the documents were drafted, and the parties were about to sign, and thus the contract for the sale of the house was just about to be formed. And just before that, the buyer asked the seller whether the house had a problem with white ants, which was a problem in the region. And the seller said no problem with white ants. So they went ahead and signed, and of course, as it turned out, there was a problem with white ants. Here the court held that because the statement was made right at the time of signing the contract, I mean, it's right at the time of formation, for that reason, it was held to be a contractual term. Or in other words, the seller at this point made a statement and the buyer had no chance of going to check the statement, double check whether it's actually true or not true. So as a general rule, look at when the statement is made. Is it made quite a long time before formation of contract, or is it made just before formation of contract? That is another criteria that you can look at. A further criteria is where a party has stipulated the importance of a term. So sometimes a party might say, such and such is of crucial importance to me as part of their negotiations while buyer and seller or whoever are trying to form their contract. Now, where a party says that something is of crucial importance, the courts will usually infer that it is in fact a contractual term, notwithstanding that in general terms it may not be important at all. And so Bannerman and White is a good case to illustrate this. This was a case for the sale of hops, and of course hops is something you need to make, for instance, beer. And the buyer had made it very, very clear that they did not want hops which had sulfur used in their production. So hops without sulfur. Now, generally it may not matter. So to a general buyer, it may not matter whether the sulfur was used in the production of the hops or whether it was not used. But in this case, the buyer made it very clear that this was of crucial importance to them. And because they had made that clear, it was deemed to be a contractual term. So when the hops later turned out to have been made with the use of sulfur, the contract was breached because the fact that it should not have had sulfur in the process of making it was a contractual term. So again, another criteria that we can look at, and there are some other ones.